Can an employer enforce its look policy, which bans certain types of clothing worn by its employees? That was the question in the case of the Muslim employee's headscarf. In this case, Abercrombie refused to hire Samantha, a practicing Muslim, because of the headscarf she wore pursuant to her religious obligations, which conflicted with Abercrombie's dress policy. Abercrombie operates several lines of clothing stores, each with its own style. Consistent with the image it seeks to project for each store, the company imposes a look policy that governs its employees' dress. The company's interviewer recommended Samantha, finding her qualified for the job, but was concerned that her headscarf would conflict with the store's look policy. The district manager was advised that the interviewer believed the headscarf was worn because of Samantha's faith. The district manager said that the headscarf would violate the policy, as would all other headwear, religious or otherwise. He directed that Samantha not be hired, and Samantha sued. Abercrombie argued that there was no disparate treatment without first proof that the employer had actual knowledge of the applicant's need for accommodation. How would you decide this case? Can an employer discriminate against the wearing of a headscarf if it prohibits all headwear regardless of religious beliefs? We'll be back in a moment to answer that question. Can the employer ban certain types of clothing worn by employees if the clothing is part of the employee's religious practice and belief system? No, said the United States Supreme Court. This 2015 case is about Title VII of the Civil Rights Act, which prohibits two categories of employment practices. It is unlawful for an employer to fail or refuse to hire or discharge any individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of his race, color, religion, sex, or national origin. This is intentional discrimination. It is also unlawful to limit, segregate, or classify employees or applicants for employment in a way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. This is known as disparate impact. An employer may not make an applicant's religious practice, confirmed or otherwise, a factor in employment decisions. If the applicant actually requires an accommodation of his religious practice, and the employer's desire to avoid the prospect of accommodation is a motivating factor in his decision not to hire, the employer violates Title VII of the Civil Rights Act. Remember, it's a matter of law.